morning, friends. Of course, both these topics, Digital Personal Data Protection Bill and ChatGPT, are hot topics for the day. And definitely, most of you have been discussing it in your own, say, circles, and you may be having certain ideas. I am only going to supplement your thoughts on this. In fact, we are expecting this Digital Personal Data Protection Bill, we call it as dpdpb, um, to actually be presented in the parliament in the next session. We actually, current budget session is on. It has been given a kind of a recess, and then March 13th it will be again starting. According to the government, they want to present it in that particular session. Whether it will be immediately passed in the next 15 days, we do not know. But the Ministry of Information Technology is having a lot of activities, including today afternoon. They are having a public consultation in Bangalore. I feel that they want to actually tick all the boxes, saying that we did a consultation in Delhi, we did a consultation here, and then in Bangalore, kind of a thing, so that they can go ahead and implement, present the bill. Okay, I think some of you have to mute your mics, please. Okay. Okay. Now, from the corporate side, say if you are a senior executive, there is a dilemma. Now, is it time to think of compliance of dpdpb to 2022? That is how it is called. Now 2022 is over. Now we are in 2023. So if the act is passed, it will be called Digital Personal Data Protection Act of 2023. But anyway, the question which confronts most of us is, why not we wait until the law is passed? Because why should I spend some money now, and tomorrow if law changes, what again I will have to perhaps rethink on that. There is another school of thought where
Pradeep Balaji, if you can mute yourself, that would be great. Pradeep Kala, can you please mute yourself?
I think admins will have to look at muting the thing. Okay. Now, the other school of thought is we will wait until the competitors start acting in compliance. But somehow I feel that it is always better to start early, because compliance is not an overnight kind of an activity. It takes a lot of time. The more time you take, more mature you would be at the time of implementation. So it is better to start as early as possible, make changes as we go along, and maybe a lot of course corrections will be required, but that is better than waiting until the bill is passed, signed by the president, and then notified along with the regulations and so on. There are many formalities it will go through. We expect the government will give time for implementation. They will also give further time before perhaps the penalties will kick in, because the government has to set up a data protection board, so they themselves will require 3 to 4 months after the passage of the bill for everything to kickstart. So there will be time, but it is better to start early so that we are not caught later on by our own complacency. Now, to be compliant, what we need to do is to design and set in place a data management system for compliance. Okay. Now you have heard of ISMS, Information Security Management System. I personally call something as a Personal Data Protection Compliance Management System, PDP CMS. That is, the system which we are designing should be correctly configured for the purpose of personal data protection from the compliance point of view. Then the natural outcome would be compliance by design. See, people talk about privacy by design, and say that as a company, I will try to protect the privacy of a citizen as per the constitution of India and so on. I personally consider that let as corporate entities follow what the government has stated in the law, and look at compliance. Let us leave the legal implementation of whether it will satisfy privacy or not to legal pundits, because we cannot interpret what is privacy, because privacy as a concept itself, the Supreme Court itself has not been able to define. Even the Puttaswamy judgment has not given a proper definition of what is privacy. They have only spoken about this could be privacy, that could be privacy, kind of a vague kind of a thought process. And that is one of the reasons why the government decided that we will call this bill as a digital personal data protection bill. They also have avoided the law to take care of the complete privacy protection, because privacy includes information privacy. That is what we are looking at now. There can be spatial privacy, there can be any other kind of privacy. In fact, all the earlier Supreme Court decisions in Karak Singh case and others, some of you, if you are lawyers, will know, they were all related to physical privacy. That is, whether the police can visit a person in his house, something of that nature. That is all called physical privacy. Now we have got something called information privacy, and people like us are talking of neuro privacy also. Now the government has decided that we will try to make this specifically a law for information privacy protection. Let us leave the controversies of other things separate. So in a way, government has taken a cue from the uncertainties about a different definition of privacy, which was there in the um Puttaswamy judgment, and said that if you yourself do not know what is privacy, then why I should worry about defining it? We will straight away go for a law where we will say if privacy can be infringed through, say, information, that is a computerized information, I will try to set a kind of uh, reasonable practices so that the privacy gets automatically protected. So the law itself is only talking of personal data protection, and therefore we need to be compliant with the law. This law is very simple. It has got only about 30 sections as compared to the previous version of 98 sections, and the government feels that industry would welcome this simpler version of the law. Of course, when you are trying to implement the compliance by design, there are at least three distinct phases. One is, of course, the creation of policies, which will be the guidance for different, say, professionals within the organization, departments, and others, and then putting appropriate technical controls which will help in the uh, policies being effectively implemented. And third phase, of course, which is a continuing phase, is the workforce transformation. Workforce transformation basically ensures that every individual who works in the organization is actually internalizing the privacy culture as represented by the compliance, and he will be able to support the organization for compliance. Compliance is not something which one data protection officer in an organization can do. It is an enterprise level activity, and that is also the reason why we say that we start early so that we will be able to take this message to every nook and corner of an organization. Now, a prerequisite for designing compliance is, of course, the understanding of the essence of dpdpb 2022. So I will just go through in a few slides the essence of this whole act. Now, because the questions we need to answer as technology persons or even the top management persons, you may be a marketing officer, you may be a vice president technology or compliance officer, or whoever you are. When you are in the top management, there are certain questions which you need to answer. One is, what are the consequences of non-compliance? Obviously, everybody will first think of it. What if I don't comply with? Will anything bad happen? We have been doing business for so many years. Now, that is one question we have to answer. Then, am I required to be compliant? That is the eligibility aspect. What is my role in the compliance? Because eligibility comes with a definition of who is a data fiduciary, who is a data processor, who is a consent manager. So there are multiple roles which a person can be identified with, and that determines the eligibility. Of course, eligibility also is dependent on what data we are talking of. See, if I am collecting data from EU, what I am required to be compliant with maybe GDPR. Does Indian law apply to that? Is a question which I have to sort out now. Today, every digital organization collects personal data from all over the world, and there are 130 plus countries which have their own data protection laws, and maybe the whole data set which we are having, we need to look at all these 130 laws and be compliant with it, because for different data sets different laws will apply. So where does dpdpb come in? So that is part of the eligibility which we have to look at. Then if we consider that we need to do that, then what principles of processing I should follow, what kind of rights I have to protect for the data principles. If all these things are there, what framework should I follow to make my work easy? These are the questions which will be lingering in your mind, and with this I am trying to give you a perspective view of what dpdpb 2022 is going to present. We have about six uh, uh, chapters in this particular act and one schedule. One is, of course, the preliminary chapter which talks about definitions. Then we have got obligations, we have got rights, and some special provisions which take care of the cross-border transfer and other things, and a compliance framework, which is the authority, and some miscellaneous aspects. So the first thing we will look at is the consequence of non-compliance. GDPR talks about 2% of turnover, 4% of turnover, and so on. Here, the government has taken a stand to define penalties subject to a maximum of 500 crores for a specific instance of non-compliance. Now, if there are multiple instances of compliance, non-compliance, then it may be multiplied by 500 crores. This principle is similar to what is used in HIPAA. Some of you who are aware of HIPAA, there also there is a possibility that the penalties may get multiplied if there are multiple types of infringement. So same principle will be used in India also. Otherwise, the penalties for individual violations could be 200 crores or 250 crores. For example, the need to have security, if reasonable security safeguards are not implemented, there may be 250 crores of penalty. Now, if data breach notification is not handled, it can be 200 crores. Then there are certain aspects of children or something like that, that is also 200 crores. That is minors data, taking consent, and so on. Then significant data fiduciaries, whoever is classified like that, will have to appoint a DPO, they have to conduct a DPIA, they have to use the services of a data auditor. If that is not complied with, there will be 150 crores of fine. Now, maybe this is one of the things which you have to first look at, because the moment the act comes into effect, you have to check whether you are going to be a significant data fiduciary or not. And if you are a significant data fiduciary, you must have a person called the DPO designated in the organization. And then you have to look at the DPIA process where it will be necessary. There is a small penalty of 10,000. This is again a very unique feature of dpdpb, in the sense that this is applicable to data principles. See, we say that data protection law protects a data principle or a data subject, but here is one section under which a data principle may be imposed a penalty of 10,000 if he is irresponsible and if he tries to harass an organization with some false requests and so on. this is one of the duties of the data principle which has been mentioned. Remember, there are many organizations, particularly in USA, which actually um, we in normal legal these things we used to call them as ambulance chasers, no, like that. Okay, these people, they just pick out a company and keep on sending some emails, like, are you um, processing my personal information, some email address, something they may give. Now, to answer that email, you will have to spend couple of hours of your top management time, because if you wrongly confirm that you are not processing, then you may be open to further litigation. So many organizations, one of the organizations I have pointed out was a company called Privacy B, that they actually made it a business model to send out requests to companies whether they are processing my data. If so, what are the details? And the more questions they ask, um, then the receiving company is open to at least spend time and energy to answer those questions. So if any data principle resorts to any false information for um, seeking such kind of information from the companies and so on, then that violates the duties of the data principle and therefore could lead to some small penalty. Now, wherever nothing is mentioned, there is also a 50 crore penalty. So we can say that up to 200 to 250 crores could be the kind of penalty that, of course, the data protection board, that is how it is called now, data protection board will be able to put a fine much less than this 200 250 crores. It's not that you have to be fined so much. So because in one of the guidelines which they have stated for the imposition of the fines, they have stated that data protection board will consider the ability of the accused in meeting the fine. So if there's a small company, an SME, they are not going to impose 200 crores or 250 crores. So that is again another protection they have given to the companies. So both these duties to the data principle as well as this restriction on the uh, maximum amount of fines, they are all industry friendly regulations. And there is also something called voluntary undertaking. That is, after an accusation has been made, this voluntary undertaking essentially means something like compounding. That is, you enter into a compromise, you tell the data protection board that we are sorry, we made a mistake, but we have taken these precautionary measures now so that this thing will not happen again in future, something of that nature. And if that is accepted, then this penalty process may be stopped. Okay, so that is another thing which actually the data the companies should consider as a good proposition. And even when inquiries are being made, this law says that the inquiry officer of the data protection board will not seize any equipments of the company and will not stop its day-to-day activities. So the question of the inquiry officers coming and stopping your business does not arise. So without the industry asking, there are many things which actually are good for the industry, which are part of this dpdpb. These things were not there in the earlier bill or even in GDPR. And it is suggested that this data protection board will be a virtual organization, and most of the things will be done, including their management governance, will be through digital means. So mediation, arbitration is being suggested. So there is a certain specific thought to make this whole process industry friendly. That is all as far as the data protection board is concerned. But remember, an organization which is processing data is also exposed to other regulatory organizations like the normal police, law enforcement agencies, certain, and there are certain instances where The adjudicator under Information Technology Act may also become relevant because personal data breach will come under the Data Protection Act, whereas non-personal data breach will come under ITA 2000. Plus, the powers of the certain as of today continues for the entire data, personal and non-personal. But we hope that certain and the Data Protection Board will have some kind of a coordination so that they will not harass the organizations from both ends. But you should recognize that the regulatory structure includes law enforcement agencies, certain adjudicator under Information Technology Act, as well as, of course, the court. But we may focus more on Data Protection Board as far as this act is concerned. Now, looking at the applicability, now, first thing is whether you are a data fiduciary, processor, or a consent manager, or if you are a data fiduciary, are you a significant data fiduciary, or you are a person who can claim yourself to be an exempted category of persons. And also the applicable jurisdiction of data protection law. As I told you, if the data is of India, it will come under the Indian law. If the data is of a foreign country, different laws may be applicable. There are enough provisions in this act where if you want to process only, say, EU information, because you are a BPO doing processing for somebody else, this government says that I don't want to interfere with your work. You please look at it as some kind of a separate unit processing the data of, say, a particular country, and I will give you exemption from the dpdpb. But you may have to have some documentation and perhaps have a segregation in terms of technical architecture, that data from that EU is coming only to this particular data protection, this data server, and that processing is being controlled by a contract which is the data controller, data processor contract. So some documentation will be required, but if you do it, you can ensure that you will not be affected by the personal data protection bill which we are talking of today. But remember that some aspects of Information Technology Act may still be applicable to you, and you have to see that you will not be in violation of other laws. Now, in terms of technology, it means that if you want to identify your role, you need to have an ability to discover personal information, classify them. You have to identify the collection points along with the country of origin. You have to know where the data is stored, who is in charge of the storage. Then, because identification of the legal basis of processing depends upon the country of origin. You also have to have technical controls for accuracy and updation, then the access control, disclosures, archival, pseudonymization, all these things which you are aware is part of the current practice of data protection. What I am trying to highlight here is whatever you are doing today as data protection, you may be doing it collectively for all the data of the organization. First bifurcation you have to do is personal data and non-personal data, and the DPO will be responsible for the protection of the data, personal data, for which the guidance is this law. And there itself you may have to know that with a proper classification and segregation, you need to have a understanding of which law is applicable for which data set. Now, once the law comes into existence, whatever data you already have, the legacy data, you may have to take a fresh consent, which means that one of the first activities you have to deal with is classification and understanding what kind of personal data I am having. If that personal data falls under the applicability of this particular act, that is, the data is collected in India in electronic form. This is one of the criteria. Then that data you will have to seek consent. Now, if you have collected data in non-electronic form, then this law is not applicable because this is digital personal data. But after collecting it in paper form, if it is digitized, then that will come under this particular act. Now, if an Indian company is having an activity outside India, if that activity is also related to the Indian data processing, obviously it will be part of the act. But if you are having a setup somewhere in, say, Spain, and you are doing processing of only Spanish data, you can seek complete exemption from this data protection law. That is all the advantages which this particular act has given. Now, when you look at the controls to be developed, one is the principles of processing, like data minimization, etc. But what is also important is the rights. There are only the right to information, right to correction and erasure, right to grievance, and right to nominate. Four different rights are mentioned. Right to information is right to access and information. Where a person asks you about the information, you have to verify the identity and then go ahead and find out whether you have his information. Now, right to correction and erasure, there is one small doubt whether this is equivalent to right to forget. As of now, people like us interpret that right to forget is not considered as a right protectable under the data protection law. If somebody still wants right to forget, they can always go to the court and get an order. But whether a company is expected to have provide this right to um, forget, which is otherwise interpreted as deletion of the data from every place which the company may possess, in such a manner that you will not even know that you had processed a particular data. That is the real forgetting kind of a thing. But earlier in PDPB 2019, we were saying that right to forget means that you will stop any disclosures of the right, whereas you may continue to have the data for your own internal purpose, like wherever legitimate interest is there. Now, this point needs a little more clarification, but as of now, what I try to interpret is that there is a right of erasure which is at the end of a processing, because all the collection and consent is purpose oriented. Once the purpose is over, it has to be deleted. So that is right to correction and erasure. But right to forget is not part of this act, but it is a legal right which anybody can enforce. Now, right to grievance redressal is an important right. This has to be provided to the data principle, and this does not end with your technical help center. You need to have a mechanism by which the legal questions which arise out of this law, like the principles of processing not adhere to, security not adhere to, duties, I mean, the rights not provided for, that kind of questions which arise, which are not normally handled by the call center which is handling technical queries, there needs to be a grievance redressal mechanism which may contain an ombudsman, it may contain a mediation process, and probably something more. Of course, arbitration, if it is there, it has to be a with recourse arbitration. So we can stop at ombudsman, negotiation, and let us say mediation. So this has to be provided as right to grievance redressal. Right to nominate is a very, is again a new thing which could create some issues in companies. What nomination essentially means is that a person will try to dispose of his assets uh, after his death to be handled in a particular manner. This is what we call as nomination. In India, Information Technology Act has stated that the electronic documents uh, will not be recognized after the death of a particular person in terms of any consent contract he might have given. So even in the data protection law, the consent is a contract. Now contracts actually get extinguished on the death of a person, and any instrument in electronic form which speaks about the transfer of assets after death, which we call as a will in common parlance, is not recognized under Information Technology Act. So if there is a document of nomination and it says that after my death I nominate my data to XYZ, that becomes a document. If it is in electronic form, it will not get any legal recognition, but it can be in paper form. A person can leave a paper will or a paper nomination and say in that paper nomination that after my death my email account password can be given to my son so and so, or something like that. So the dpdpb, without perhaps giving enough, you can say, recognition to the prohibition under Information Technology Act, has included this right to nominate, and you need to actually find a hybrid mode where nomination is taken in paper form and kept, and thereafter it is disposed of. Now, is it required to have this right to nominate? Maybe you should look at the upcoming era where electronic information consists of not only, let us say, passwords. It contains, say, your bank account numbers, it may contain your NFT information, it may contain your crypto information. We don't know what kind of digital assets are present in a let us say a Dropbox or something you have created. So right to nominate will ensure that the nominees will be able to get access to this Dropbox or any other digital asset, and it may contain very valuable say assets like a bank locker containing the information. In the case of a bank locker, there is a system which is relevant here also. Say in the case of a bank locker, if a person dies, then the nominees or even the people who hold the rights under the will, they do not know what is contained inside the locker. They cannot get a probate for the will or any other legal document to establish their ownership for contents inside the locker. So what bankers normally do is, in such cases, they will allow the legal aids in front of some independent witnesses to open the locker, take an inventory of the information, and then it will be closed, and then these people will go to the court and get the relevant orders. A similar system may have to be introduced in the electronic world, that this right to nominate may be restricted to right to disclosure of the assets, but ownership, to whom it has to be transferred, if there is no written paper, there will be some kind of an issue to be checked. In fact, the duties which I was mentioned, these are the duties which a data principal will have. One is, data principal shall comply with the provisions of all applicable laws, which means that any person who is not a law-abiding citizen, who is perhaps a criminal in some way, okay, he is not eligible for the Indian law protection, that person will not be eligible to get any benefits under this act, because it is one of his duties that he shall comply with the provisions of all applicable laws. A data principal shall not register false or frivolous grievance. A data principal under no circumstances, while applying a document or a unique identifier, furnish any false particulars, and will furnish information which is verifiably authentic. So you can imagine that these are all specific provisions which will help the industry, and it has been put as duties, and if duties are violated, there is a 10,000 rupees of fine for that. Now, other obligations which are what we call as principles: one is data can be processed for lawful purpose, and multiple languages notice has to be given, that is in 22 different languages. Here This is somewhere you can use your chat GPT and give automatic translations if it is possible, but you will be liable for any wrongful translation, because whatever say automated processing you use, they the responsibility of that remains with the user, the person who has used the particular automated process. Therefore, when you do automated translation, if the translation is not clear, then that deficiency in translation responsibility will be applicable to you. But otherwise, you can see that at least in 22 languages, if I remember correct, you need to have the notices, and it has to be itemized notice. So it is more or less like an explicit consent, and it has to be by an affirmative action. Withdrawal of consent is permitted. And then one more aspect of Indian law is the role of a consent manager. There could be an intermediary organization whose business is to act on behalf of data principals and then negotiate with the data fiduciary and ensure that data is provided on need to know basis only. And this consent manager is a data fiduciary, and he will be requiring some kind of a registration perhaps with the data protection board. But this consent manager will not be any Tom, Dick and Harry. He will be having a lot of responsibilities, much more than an individual data fiduciary, because this consent manager handles the information and distributes it to multiple data fiduciaries. But look at the advantage of this consent manager. We are talking of Indian data principals who do not have adequate appreciation of privacy. They cannot decipher the request for permission from a data fiduciary why a particular information is required or not. And at the same time, this language problem also is there. Now, if there is a consent manager, the consent manager can take care of explaining to their customers, who are the data principals, about any particular data fiduciary service, and depending upon the requirement, they can control whether they have to give the full personal data to the data fiduciary, or pseudonymized information has to be given, or a de-identified information has to be given, and so on. In the sense that this consent manager will act as a filter between the data principal and the data fiduciary to ensure that only required information goes to him. It is like in your Aadhaar, you have got this proxy tokenization or something, which is possible, where you have a masked Aadhaar or sometimes a completely virtual Aadhaar number. Now, this consent manager can actually create pseudonymized information of the data principal. And then if, let us say, if Zomato wants the information, they want only location information. They are not interested in your personal information, not even your name or gender. Okay, so pseudonymized information in respect of name and gender can be given, and location correct information has to be given. So that kind of control can be established by this consent manager. It has got a lot of potential. Maybe we have to discuss it separately about a business opportunities in being a consent manager. But today we can only see that a data fiduciary should be ready to receive the information directly from the data principal or through a consent manager. Consent managers may actually develop their own APIs. They may actually tell different data fiduciaries that in your form for seeking information, please provide for a pseudonymized ID or something like that. All our customers will use only that pseudonymized ID, like this virtual Aadhaar ID. And that kind of technical development will come in future, and it will control this issue of languages, issue of uneducated persons not understanding the permission requirements, and so on. There is also a concept of deemed consent, which is important for companies. Say earlier we used to say that there are certain exemptions from consent. Now the same thing is there for deemed consent. And in deemed consent, the most important aspect for companies is that information which is required for recruitment, termination of employment, and so on, basically the employee information, lot of that comes under deemed consent, which means that, as it happens in EU very often, employees, particularly after they leave an organization, they become a big threat to the organization because they present a risk of raising some kind of an objection with some internal information, and in data protection area that becomes very difficult to handle. Now, for example, you have to actually do monitoring of the employees, because without monitoring you do not know whether a person is suitable for an employment, whether he should be given a rise or something like that, and therefore surveillance of employees is also a requirement. So some of those things um, could be considered under deemed consent. um, of course, this will be perhaps debated more, but I feel again this is something which is required for the industry. Otherwise, internal employees who are privy to a lot of internal information can become rogue employees after they leave the organization, and uh, not simply try to post some um, um, adverse information about the company, but also they may go and file a complaint with the data protection board and create problems. Deemed consent is also covering the legitimate interest, medical emergency, and public um, interest. Information which is publicly available, that is also coming under deemed consent, so that in case you are scraping the data from a public source like the Google, you may be able to consider that there could be some provisions of deemed consent which is applicable for the person who is doing the scraping. Then if Google does not have the right to take that information, that is for Google to explain to the data principal. So there are certain things which are again convenient for the industry in my opinion. Now, general obligations, like in any other act, accuracy and completeness of the data, security safeguard should be there, notification of data breach should be there, and when the purpose is completed, data has to be removed. These uh, other people publish business contact information of the data protection officer, grievance redressal, and whenever you appoint a data processor, have a proper contract. The special cases, one is the minors, you need to have a verifiable parent consent, and no harm should be there, no tracking of behavioral monitoring or targeted advertising should be there for the minors. There is also one specific aspect here where the minor and the guardian, more or less, they are considered as joint data principals. Now, legally, how it will work out, we'll have to still wait and see. This is again a new concept, but I think it has got its own advantages, particularly when you have to have the transition of the erstwhile minor when he becomes a major. In the present circumstance, what happens is, at the stroke of midnight, when a person attains the age of 18, his parental consent ceases to be effective, and you have not yet taken the consent of the particular person. Therefore, the services will have to be abruptly stopped for certain time. Now, maybe this joint data principle kind of a situation may come in handy, so that you can have a kind of a changeover cushion for, say, maybe 15 days, maybe 1 week, when the earlier consent which has been given by the parent will be considered as a deemed consent for the erstwhile minor, and then within a reasonable time get the minors, uh, the person who was earlier a minor, now he is a major, get his consent. These are things which will be either specified by the notification. If not, the frameworks which people like us are developing, like this personal data protection standard of India, we would have already incorporated this as a guideline for handling the minors data. This is the reason why when we come to the framework, I will say that the FDPPI's personal data protection standard is a step ahead of any other frameworks which you may see in the marketplace, which may come from much larger organizations or standard organizations. But I can confidently say that the PDPSI and corresponding audit and certification takes into account this kind of very specific situations where the Indian government is perhaps yet to formulate a full particular say guideline, but we need to come to something which is reasonable. So those are the things in minors. Transition is one area. Then the disease data principles, I told you about the nomination, how to handle the nomination, and how to verify a claim, settlement of a claim. These are all things which again you have to go to the PDPSI to find out what is the best practice, because this is not to be found in ISO 27701 nor in any GDPR compliance. In no other framework you will have this kind of an information. Only in PDPSI you will find somewhere in the corner how to handle the deceased data principles data and what kind of systems need to be built. Coming to another important aspect, which is cross-border transfer restrictions, again the government has taken a strategy where, without specifically mentioning what is possible, what is not possible, they have simply said that we will come up with adequacy agreements with multiple countries. So that is one way by which we will be able to have multilateral treaties kind of a thing. Then they have also indicated one again very innovative thought, that they may recognize special data processing zones where um, a, a company which is processing the data of a foreign say set of citizens, they will be allowed to have a separate say technical zone which is called a special data processing zone, and it will be handled something like a diplomatic immunity zone kind of a thing. In fact, this kind of a suggestion was made about 10 years back by me. I used to call it as a privacy zone. We should create like the STPC kind of a thing. That was the time when we didn't have the law. I was saying that if you still want to attract the data processing in India, we will create such kind of a zone. And some recommendations of this was also made to the Karnataka government even about a year back. But obviously, governments were not so reactive to that kind of innovative suggestions. Now, this has been mentioned by the minister, Rajiv Chandrasekhar, in one of his interactions, that they may recognize the special data processing zones, which means that either through bilateral agreements or through special data processing zones, cross-border transfer from the EU country to here will be handled. We will not have, we should not have the problems like what was there for the US privacy agreement, Schrems agreement, decision of the EUCJ and so on. So I think we will be finding a innovative solution for cross-border transfer. Now, all these complications, how do we bring to the framework of compliance? Please look at PDPSI version 2023, which will be the one which we will be doing after this new act is announced. If any changes are to be made, we will be making that. This will be more focused than ISO 27701 or IS 17428. It will be flexible to address the compliance of GDPR, these special data zones, and the DPDPB in general. It will incorporate the DTS, that is the maturity measurement of compliance, and it will be, as of now also, it is amenable for self-assessment by the organization, then mentor-assisted assessment and certifiable assessment. I am not going into the details, but I am only making a mention here that you should not ignore the presence of this kind of a framework before you run for compliance. Now, where to start? You have to start with designating the accountable person, then make a self-assessment of your present condition with a DTS evaluation, which will generate a gap assessment report, then define the risk absorption capacity of your organization. With that, you develop a compliance charter and then ask a team for compliance to handle the implementation. This is what I call as the roadmap which you need to develop. But in this roadmap, the most important thing is to build that privacy culture amongst the workforce, for which you need to have awareness building, acceptance by the workforce, then appropriate role identification, providing appropriate tools, but at the end, giving some incentives for good behavior and also some deterrence in the form of sanctions. A motivational program based on this hexagonal model will be required to implement the roadmap. Now, please look at this PDPSA framework. And when you do that, one of the things which you need to remember is, don't have a bias created by your earlier experiences with GDPR, in the sense that if you think I'm already GDPR compliant, why I should do something else. That should not be done, because GDPR compliance is different. This is different. Please look at the details there. Of course, FDPP also has got the certification and other aspects. Now, before we end, I would like to spend a few minutes on this chat GPT. We are all aware of the advantages of chat GPT as a language model to generate human-like conversation. And but we must remember that the intelligence of this chat GPT is limited to the training which it has received. And if the training is limited to data up to September 2021, which is in the current version, uh, you can expect only that much of intelligence from the chat GPT, unless of course new versions will come which is able to take concurrent information from the web. But one thing we must remember is, if this training has been based on web, and web, we have Wikipedia, Twitter, websites, blogs, etc. Many of them contain incorrect data. We can expect that this model could have digested incorrect data and could have developed a kind of bias. So don't expect ChatGPT to be a reliable provider of information in the corporate entity. If somebody is doing that, they are making a big mistake. In US particularly, I saw recently that 50% employment has been cut and replaced with chat GPT. If it is true, it is a very bad thing to have done. And of course, we also have seen that one US court wants to use chat GPT for delivering judgments. These are misapplications of chat GPT, because chat GPT is not that capable. Okay, otherwise you are going to use it in customer service and help centers, employee training, and some assistance in coding. For it can be used, but ultimately the coding will have to be supervised by a human. Content creation for blogs and emails, maybe you may use it, because many of our employees are not good in writing, say, emails in English, kind of a thing. Knowledge management, and in terms of marketing and sales, maybe there may be some ways of using chat GPT. But remember one thing, that when we talk of incident management, when we look at techno-legal incident management, the person who is receiving the first information about an incident should be capable of identifying whether there are any legal issues. That is why we say that a human intelligence is required for the incident management receiver, that is a person who receives the first information. Chat GPT, if it is used, it is unlikely to be capable of understanding techno-legal issues. See, one problem with chat GPT, as we have seen in the recent things where one New York reporter reported something, and one more person, two people have reported that chat GPT seems to be presenting itself as a know-all kind of um, and uh, assistant. And we have seen that it is not consistent with the training which it has received. In the New York person, that is Kevin Rose, the chat GPT went to the extent of saying, I love you, I want to marry you, kind of a thing. Now the question is, where does that information come as far as chat GPT is concerned? A chat GPT has been given some kind of a leverage to say crack jokes. So perhaps at some point of time it thinks that it moves on from factual dialogue to some kind of a joking. I think that is where this kind of rogue replies are coming, and in the organization we cannot actually accept such things. So human oversight is essential in terms of coding. If any malicious coders are behind chat gpt output, then malicious bugs will get included. So please do not have a blind faith in chat gpt and ensure that you use it to the extent possible, but don't jump to every decision what does chat gpt say kind of a thing. Over a period of time some people will develop that kind of say attitude. We have to actually be aware of that, and you may have to look at chat gpt risks as a category in terms of your information security, which may happen because of inadequate training of the algorithm, inherent bias, and hallucination of the ai bot, like what happened in that kevin rose interview. Rogue behavior which will come sooner or later. Some of this the developers may say that it is not intended, it happens just like that. Like anyway, I will not go into the details of that, but current tendency is that the bot can say something which it is not meant to say, and that is the risk which we are having. Tomorrow it may give out a report on marketing which is actually a mischievous solution, which if you use it, it may land you in some kind of a trouble. Other than this, employee diversion could be one of the risks. Then need for an assurance certificate is necessary whenever you use AI in data processing. dpdpb already has a provision saying that automated processing is within this act, and that includes the um, chat gpt kind of algorithms. I am looking at chat gpt as a dumb but pretending to be intelligent personality. That is the risk which we are having. It is a big problem. If we don't decipher this behavior, the organizations may pay a big price for that. Remember that dpdpb says automated means any digital process capable of creating automatically response to instructions or otherwise. So even if you are having an intelligent bot which is self-learning, it is still considered as part of dpdpb, and section 11 of ITA 2000 attributes such electronic decisions to the owner. Therefore Indian law already has a measure of this particular uh, AI, the chat GPT. Now, friends, I will stop here, and to the extent time is available, can quickly take any other questions.
Uh, okay, let's take one or two questions. Anyone wants to ask anything with Naavi sir?
Yeah, good morning.
Good morning.
Yeah, good morning.
Good morning. I just have one clarification. Sir, Navi sir mentioned about, the role of the consent manager, right, between the data fiduciary and the data principal. Now, who is responsible for, hiring, is it a company's or responsibility, data fiduciary responsibility, or these will be third party, people who will be there in the market? So just want to clarify on this
It
point.
has to be a third party. It is an intermediary. It has to separately register itself with the data protection board, and there will be conflict of interest between the consent management and the data fiduciary. So data fiduciary cannot create its own consent manager. Like you cannot have a department which will act as managing the consent. If you do it, it will not be a consent manager. It will be your own division which will be doing it. But this consent manager is a concept where the data principals will actually provide, or they will appoint something like a trustee. Okay, so this is a trustee organization. They will have to develop their own business model on that basis, and they have to convince the public to become their members. give their personal data to them and then authorize that consent manager to in turn transfer the personal data to anybody else. Even in the current IT environment in the financial sector, there is a consent manager system. That consent manager system, which is there in the RBI guidelines, is slightly different. It is a technical intermediary where it is like a platform. Data comes from one place and it goes to their place. Suppose you are a user of data, you ask for that data, and then this consent manager under this data protection, the data framework will collect it from data suppliers and pass it on. There, it is just a technical intermediary without visibility of the data. Whereas what is being presented in this act is the data consent manager knows your real ID, knows your real information. So it is a data fiduciary, but while transferring it to a third party, he will apply a filter. Okay, so it's a different business. It is a intermediary business. You can take that business from the individual. So it's a consumer business actually. And then on the other hand, you have got the business. You convert the consumer's information into business consumption. Okay.
Okay, so that
sir,
means
one-
so just a clarification. So that means these consent managers will be certified from the board, right?
Yes.
So they
Yes.
have to get certified.
Yes.
Yeah.
Yes.
Okay.
Yeah.
Okay.
There will be separate guidelines for them. Yeah.
Okay. Okay.
I would request Vivek, you can ask your question. Vivek Daria, very good question related to the certain guideline, what he's asking. Vivek, are you there? Okay. Anyone else like to ask anything?
Yeah, Kapil, I have a small query here.
Yeah,
Can I?
please.
Yeah. So basically, it's related to where to start. There was one slide where it was mentioning like we have to hire a designated accountable person like compliance officer or a DPO. So my query is like whether it will be a third party or like how whether government will provide us some kind of certified vendors who will be helping in that. And my second question is like the self-assessment of DTS. This is responsibility of the data manager who is sitting in the organization, or it will be helped by the compliance officer as well.
See, in the earlier PDPB 2019, there was full clarity that the DPO should be an employee. Data protection, data auditor is an external person. Okay. Whereas this version doesn't at present say specifically that he should be an employee or he should not be an employee. And it says that he should be appointed. Okay. Now, the word appointment sometimes we associate with employees, but they have used the same appointment even for data auditors. It says the company should, significant data fiduciary should appoint a data protection officer, he should appoint a data protection data auditor. We know data auditor is an external person. So therefore, we can imply that at present, unless anything to the contrary is made, there can be an external data protection or officer like it is possible in GDPR. Earlier it was not there. Here at this moment I am saying it is possible. I may change my view after the government comes out with more clarification. Okay. Yeah.
Kapil, can I come in?
Yeah, please.
Yeah, thank you. Thank you, Naavi, for the excellent session, first of all. And very, always very, very, very good session always, sir. Thank you for that first.
Yeah.
And sir, my small question is that in terms of ChatGPT, is the usage of the ChatGPT in the business, application or something like that, that is some kind of compliance or not?
No, for us users, it is just a tool. Okay. It is an automated tool. And if I use that tool, I am responsible for its output. Okay. That is the section 11 I am talking of Information Technology Act. Okay. Now, according to the description of ChatGPT, it is a language model, which is only that it can only speak, okay, by adding words and other things. It need not know the facts. It will only it is actually creating imaginary words only. In fact, how else you can describe a language model? Language model creates a chain of words based on its training. Okay, it is not a know-all kind of a thing. Whatever it knows, it is from the training. It is in your corporate, if you create a chatbot, you give a specific database, they are reliable facts which you have supplied to them. So any output coming from that chatbot is reliable. But this chat GPT, which is something which has been created out of the web-based learning, will always come with its own bias. Okay, bias may not be racial, but bias is there because web data itself is not reliable. Okay, you look at any news item today, you will not believe the WhatsApp message or something. You will just check with somebody else, or you wait for a second confirmation. Why? Because we know that everything which comes on the web is not reliable. But chat GPT training has been made on everything which was available on web from a particular time up to 2021 or whatever is that. So I have a feeling, subject to correction by technology people who know what is inside, that it will be a good say source of information. I have my own doubts because Wikipedia itself contains a lot of incorrect information. In science and other things it may be more reliable, but in current affairs.
Thank you, Naavi sir. Really, it was very insightful session. I can say so many things because we have learned too much, and our entire colleagues of CIO, CTO has learned too much on this. Basically, they want to learn too much more from you because of the time constraint. We can't extend the time. This is the only reason. And thank you very much. And once again, we'll meet you, sir. Thank you very much. Thank you, Kapil. Over to you.
Thank you, Naavi sir. Any last comment on it?
No, it was
Okay.
it was nice interacting with all of you. I'm happy. Okay, yeah.
Thank you, everyone.
Thank you. Thank you.
Sir, very
Thank you, everybody.
insightful.
Thank you very much, everybody. Thanks.
Thank you very much.
Thank you.
Thank you.
Thanks everyone for
Thank
joining.
you so much, Kapilji.
Thank you. Thank you so much.
Recording stopped.